Hello, everyone, and welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers here, as I mentioned, for another live Q&A. Welcome, everyone who's tuning in. We've got half an hour lined up right now to answer any and all questions with respect to your employment, whatever kind of situation you're dealing with at work. Perhaps your boss is mistreating you and you feel like you're getting the short end of the bargain in your employment. Maybe you've been let go from your job and you've been offered a severance package. We'll actually touch on that shortly with a specific example. Or maybe you're dealing with a change in your workplace. Maybe your employer is changing your compensation package or a commission structure or a bonus plan. Maybe your employer is asking you to do different job responsibilities or tasks in the workplace, or maybe you're being demoted in your position. Any kind of major change in your employment. All of these examples should be raising a red flag that you need to be speaking with an employment lawyer in the circumstances. Employees in Ontario and in Canada more generally, and we also have offices, by the way, in British Columbia, in Alberta, but really all employees in Canada have quite strong employment law protections. Employees are actually quite well protected in Canada when it comes to employment laws. But of course, the law cannot help you if you don't know the way the law works. And so again, whenever you're feeling that resistance, whenever you're a little unsure of what's happening at work and whether what your employer is doing is fair or not, again, that should be lighting a light bulb in your mind to speak with an employment lawyer. And this is a great opportunity to do so. I am an employment lawyer. I've been practicing employment law for 10 years now, and I've seen certainly my fair share of complicated and sticky employment law situations. And so go ahead and test my knowledge. Go ahead and test that experience. Go ahead and ask your question right now over the course of the next half an hour. And I promise you, you will feel a lot better once you have a better sense of your obligations and your rights in your particular circumstances. Okay, as we typically do on the show, a couple of items on the agenda that I want to get out of the way. The first is our contact information. If perhaps you're a little too shy, a little too bashful to go ahead and ask your question online, and by the way, of course, your question could be confidential. You don't have to mention your employer's name. You don't have to provide any personal information. Go ahead and ask your question in a very general way, and you'll still get the same quality of answer. But if you want to give us a call at the office, if you want to talk privately, that's not a problem at all. I understand that perfectly. The first piece of information I want to share is our website address. You can see it on the screen right now, employmentlawyer.ca. Go ahead and visit our website as a starting point here. Of course, we've got our contact information on our website. You can find out how to get a hold of us there. We also have lots of articles, blogs on kind of recent developments in the employment law world. We have video clips. We're on YouTube and streaming platforms quite a lot, sharing our expertise, providing information. And so you can view any of those clips, of course, on our website. Go ahead and visit the website as an initial kind of starting point if you want to get a hold of us. You can also email us as well. The email address is on your screen right now. Very simple email, help@employmentlawyer.ca. That's help@employmentlawyer.ca. Go ahead and send us an email. Give us a brief description of the situation you're dealing with. You don't have to send us a 3-page email about every single occurrence that happened over the course of your employment. Keep it brief, provide the relevant information. I promise someone will get back to you and put you in touch with a member of our team. Of course, if you want to give us a call at the office as well, we'll share our telephone number. You can find it on our website, of course, as well. Give us a call at the office. Feel free to. We have an entire department standing by to take your calls and put you in touch with a legal professional. And if you have to leave a message, that's fine. Again, I promise we will call you back and we'll make sure that you get your question answered. All right, so that was item number 1 on the agenda, our contact information. Again, if you guys aren't comfortable sharing your questions right now during a live stream, go ahead and contact us off air, so to speak, and I promise we will get back to you. Second item on the agenda for today, and this is very difficult and unfortunate news. I'll share a bit of information. I'm coming to you today from Ottawa, Ontario. Ottawa is the home of the large and international employer Shopify. I'm sure you've all heard of Shopify. Unfortunately, the company just announced yesterday, I believe, very, very recently, that it's going to be laying off 20% of its workforce. If I recall correctly, Shopify certainly has thousands and thousands of employees. I think they have anywhere between 6,000 and 10,000 employees employed with the company. And if it's going to be reducing its workforce by 20%, that is a large and concerning number of employees that are going to be losing their jobs soon, if not already. We're probably looking at something like 1,000 to 2,000 employees at the very least that are going to be losing their jobs. So very difficult situation for these Shopify employees. It is an example of what's happening more largely in the tech sector. And this is going to be relevant for, of course, any professionals in that field. Certainly lots of employees that are still at the beginning of their careers or in the midst of their careers in kind of the tech world. And I wanted to speak about this because we've been certainly assisting lots of employees in this particular industry over the course of, I would say, the past 3 to 6 months. We've seen an uptick, unfortunately, in terminations in the tech sector and downsizing of employers in the tech sector. But to use Shopify as a more specific example, it's important for those employees that are being let go. And this certainly applies to employees of Shopify that are being let go, but it also applies to any other employees that are being let go from their jobs for whatever the reason, really, whether it's a restructuring or a downsizing or any other reason for that matter. There are a couple of very basic initial points that should be kept in mind. The first and perhaps most important point that I want to relay here to any employees that are being let go is to not sign off on any documentation, either on the spot or without receiving legal advice. You are going to be, if you're being let go from your employment, you are going to be sat down for a meeting. That meeting might be in person, it might be virtual, and you're going to be sat down and provided with a document. The document is going to be a termination letter that might be 2 or 3 pages long. There might be some additional documents that are attached to that termination letter that are relating to benefits coverage and other kind of procedures and administrative matters that have to do with the end of your employment. But you're going to be sat down, given a termination letter. You're going to be told that you are being let go and be provided with your end date. Your end date might be that very day. You might be let go on the spot, so to speak, and be asked to collect your belongings, again, virtually or otherwise, and end your employment then and there. You may be given advance notice of your termination. So you may be sat down and told that your employment is ending a week from now, or 2 weeks from now, or 2 months from now. Potentially, an employer is allowed to provide notice of termination. But in any event, you're going to be provided with a termination letter and likely some sort of severance offer. My point here is, again, it's extremely important, and unfortunately, we see this week in and week out as employment lawyers. We see employees simply signing off on the documents, handing it back in the moment, sometimes out of anger, sometimes out of fear. But we see employees do this, and it is the worst thing that you can do during a termination meeting. Your employer is making you a severance offer. They're likely making you a severance offer that's going to be less, and oftentimes far less, than what you are actually owed as severance. And so signing off on the spot without having received the legal advice, without having an opportunity to consider the matter deeply and decide whether or not you want to accept their offer, again, is the wrong move. Take the documents with you, say thank you very much, be professional, be courteous, be polite. There's no reason in the context of a termination for things to get antagonistic or unprofessional. Keep your cool, end the meeting, and the first thing you want to do is make sure that you speak with an employment lawyer about the company's severance offer, regardless of whether or not the offer is reasonable or not. And again, we see severance offers that employers make all the time, and almost always they are less than what an employee is actually owed. But even in a situation where an employer's severance offer may be perfectly fair and perfectly reasonable and the right number, you still need to receive professional advice in the circumstances. You still need to make sure that what the company is doing is the legally correct and appropriate thing to do for an employee. Severance being based almost always on an employee's age, position, and years of service. And so the first thing you need to do once you're being let go, you've been offered that termination letter, you've been offered some sort of severance, is speak to an employment lawyer. There are a couple of things, and certainly I would suggest you reach out to us. Let's have a conversation privately. Let's talk about the various factors that are at play when it comes to a severance analysis. You saw on your screen a moment ago, pocketemploymentlawyer.ca. It's actually a great place to start. You can visit pocketemploymentlawyer.ca. We have a severance pay calculator at that website, and you can also access it through employmentlawyer.ca. But pocketemploymentlawyer.ca has a severance pay calculator where you can input your age. Again, this is all confidentially, it's zero cost. Your age, position, years of service with the company, and you will get a rough assessment of what your severance entitlements are. It would also then prompt you to contact our office or to provide your contact information. Give us your email address or a telephone number. And again, we will get back to you. Speak to a legal professional. Make sure you speak with an employment lawyer. Get the proper advice that you need to determine whether the company's offer is reasonable or not. I mentioned already that severance is based on an employee's age, position, and years of service. Those are the three main factors that are taken into consideration when assessing an employee's severance entitlements. There are also some other relevant factors, and again, every case is different. Right? We might want to review your employment contract for any severance terms. We might want to talk about your job prospects moving forward, your employability moving forward. That might be another factor. But in any event, again, the principal point here is make sure you speak with a professional. Make sure you get professional advice that is appropriate in the circumstances. And when we're talking severance, when we're talking termination of employment, the person you want to speak to is an employment lawyer. And again, we have an entire department standing by to speak to people in exactly these situations. Unfortunately, employees of Shopify are going to be dealing with this issue moving forward. Again, for those of you just tuning in, I was just talking about a very recent announcement just yesterday that Shopify is going to be letting thousands, I think almost 2,000 employees go. It's going to be about 20% of their workforce. And I would strongly encourage all of those employees and any employees that are being let go from their job to make sure that they speak with an employment lawyer before they accept the severance offer. If you simply blindly sign off on a company's initial offer, it's likely that you will be leaving tens of thousands of dollars on the table from a severance perspective. You do not want to be one of those individuals that sacrifice that money. It's certainly better and rightfully belongs in the employee's pocket rather than the employer's. That was my case of the day, as we call it, and a chance to talk about a matter that recently came across my desk. It's unfortunately the case that terminations are happening across the board in the tech sector. I imagine we're going to continue to see layoffs and restructurings across that sector over the course of 2023. For those of you just tuning in mid-session, as a reminder, my name is Alex Lucifero. I'm an employment lawyer. I'm a partner with Samfiru Tumarkin, LLP. This is a live employment law Q&A. It's an opportunity for you to ask your question, and I see a few questions already lined up here. An opportunity to ask your questions to an employment lawyer and get your employment situation resolved. Whatever kind of issue you're having at work, I don't care how minor or how major it is. If you have a question about pensions or a question about severance or a question about temporary layoffs, or maybe you have questions about returning back to the office after having worked remotely for years because of COVID, really any questions under the sun. And if it has to do with your work, go ahead and post your question right now. I promise before the half-hour mark, we will get to it. All right, and on that note, let's get into the mix of things here, guys. I see a number of you have already asked your questions, so I will get to them. And here goes. First in line is Tigers Rangers on Facebook. Rangers asks, have you ever heard of anyone getting sued for lying on a resume? Really interesting question, Tigers. I actually haven't, in the sense that I've never actually myself spoken to or dealt with a situation where an employee is being sued for that reason. The first thing that immediately comes to mind in that respect, Tigers, is if you are suing an employee for lying on their resume, you'll have to prove, I mean, really doing that isn't in and of itself enough. You have to be able to prove that that lie on the resume caused the company damage. And so the employer, in other words, will have to prove damages as a result of that. If you cannot prove those damages, then it is what we call a Pyrrhic victory, in the sense that the person may have lied, but if no damage occurred as a result, then there isn't really anything to do there. I could tell you, going back to my previous comments made just a minute ago, if you're dealing with a situation, Tigers, or if you know of someone that's dealing with a situation where they are being sued by their employer, it's very obviously imperative that they receive assistance and legal representation. You do want to speak to an employment lawyer in that situation. It is an employment situation. I can tell you some employers, and these are typically not the reasonable employers, not the good employers, some employers are actually quite aggressive from a litigation perspective. They will sue an employee for breaching perhaps non-competition language, or they will threaten an employee for breach of confidentiality clauses. Some employers are simply litigious. But in my experience, actually, once an employee gets a lawyer on board and responds to the employer, defending the claim in a zealous way, I've seen lots and lots of employers back off in those situations. It's actually never a good look for an employer to be suing an employee in court. Judges will oftentimes be quite critical of those employers, and an employee in that situation certainly needs proper advice and proper representation. If you or someone you know is dealing with that situation, Tigers, again, make sure you get legal advice as a starting point, and hopefully the employer backs down. Very interesting question. Thank you for that. All right, next up on Facebook, Sarah asks, my husband is on disability, but is soon to inherit some family money. Does this count as income for disability benefits? Will it affect anything? Sarah, another excellent question and a great opportunity to mention. Within the realm of employment law, and as part of our practice as Samfiru Tumarkin, we also have an entire team, an entire department that handles disability insurance claims specifically. Disability insurance claims oftentimes, although not always, arise out of the context of employment, because most employers will have group insurance and benefits plans that include with them disability insurance, what's called long-term and short-term disability benefits. An employee who is medically unable to work, so they're either injured or they're ill, and that could be physical or mental. An employee who is medically unable to work for any of those reasons and has disability insurance coverage, either privately or, again, more often through their employer, can apply for disability insurance benefits. Disability insurance benefits are usually, again, a benefit that you receive when you're medically unable to work that's a certain percentage of your total salary. A lot of times it's 66% or something like 70% of what your full pay would be, again, as a kind of disability insurance. And so Sarah asks the very interesting question of, her husband is on disability benefits, but is inheriting some money. So he's going to be receiving an inheritance. And does that count as income for disability benefits? The reason why Sarah very correctly asks the question is because if you are on disability insurance benefits, right, and you are medically unable to work, you're not receiving any employment income, your employer doesn't have an obligation to pay you while you're on disability leave. A term of the disability insurance policy will be that if you receive any income, the insurance company will be able to set off, basically deduct what it owes you from whatever other income source that you're receiving. Now, Sarah, to answer your question, something like an inheritance is not going to be considered income. Certainly, if for example, a family member has passed away, right, and your husband is in that person's will, and they're going to be receiving some sort of monetary amount, right, some sort of lump sum amount as an inheritance. No, that is not considered income. It's certainly not considered employment income by any means, but it's not considered any other real kind of source of income either. Right? It's going to be considered more an asset, right, than a stream of income. And so the initial answer to your question, Sarah, is no, it should not count as income. And that means that the insurance company should not be deducting what it's paying you from what your husband will be receiving. Now, the more detailed question, Sarah, and I might even encourage you to give us a call or contact us off air. We can have a chat in more detail. The more detailed answer to your question would be, it's going to be important to have a look at the actual insurance policy, Sarah. So pull up the actual insurance policy, or specifically the disability benefits section of that insurance policy, rather. The insurance company should be defining very specifically, and oftentimes there'll be a list of kind of examples set out as to what is considered income and what is not. Right? And so we want to make sure that any kind of inheritance or lump sum payment like that is not going to be included in that definition, in that specific policy. It, of course, depends on which particular insurance company you're dealing with and the exact language of the policy that applies to you. But it's unlikely, Sarah, that it should count as income. Hopefully that answers your questions. And if the insurance company gives you a hard time, or if you want to know more about the situation, if you want to review the policy together, again, do not be shy. Contact us, send us an email, give us a call at the office, visit our website. You can go to disabilityrights.ca when it comes to any disability insurance matters, and we can look into the situation further for you. All right, everyone. Again, thank you all for your questions. We've got about 8 minutes left here and a few questions left, which is excellent. Next in line is Grace on YouTube. Grace, thank you for tuning in. Grace asks, can you receive severance if you've been working at a company for less than a year? I was told, as I was only there for 9 months, I'm only owed a week's pay as it's less than a year. Another excellent question. We've got very sophisticated viewers tuning in today. Thank you all. Grace, what an excellent question. And in answering this, I'm certainly going to be able to help you here. I'm also going to be likely going to be able to help lots of other viewers that are tuning in that are short service employees. They've only been at the company for maybe a number of months or maybe a year and a half, 2 years. It's what we consider kind of short-term employment, relatively speaking. And a lot of those individuals will be surprised to know, and Grace, this applies to you as well, that short service employees are likely owed proportionately more severance than longer service employees. And I say proportionally because I mean, even as a 1-year employee, Grace, even as a 9-month employee, quite frankly, you can still be owed a good few months of severance, right? Despite that you haven't even been there for a year. I've seen lots and really countless employees that are employed either just less than 1 year or around the 1-year mark being owed 3 or 4 months, not weeks, months of severance, despite the fact that they've been with an employer for such a short period of time. The reason why that is, Grace, is again, because severance is based on an employee's age, position, and years of service. Your age and your position, right, in addition to your actual length of employment, actually matter a lot. And what matters here ultimately is the fact that even as a short service employee, it's still going to be quite difficult, most likely, for that employee to go out there and find new employment, having been let go from their jobs. So despite the fact that the service is relatively short, right, depending on the person's age and position with the company, and certainly the higher up you are within a company hierarchy, or the more specialized your position is, the more severance you're going to be entitled to. I would not take the company's word as gospel here, Grace. It's likely that you're owed more than 1 week's pay, despite your relatively short service. And so before you accept that offer, or again, without taking their offer or taking their words, at face value, give us a call, send us an email. This is going to be a very straightforward situation to analyze. Right? I want to take a look at a few things. Again, I want to know your age and position within the company. I also want to look at any kind of employment contract that you might have signed with the company, keeping in mind your employer may contractually limit what severance entitlements you might have. So there might be something in your contract that speaks to severance, which may also be relevant. That said, I can also tell you that a lot of contracts that we see, a lot of termination and severance language in contracts that we see, isn't actually enforceable, even though an employer might think it is. And so the contract is something to analyze, but it's certainly not necessarily determinative. So hopefully that answers your question, Grace. Again, if you want to have a chat and actually get a real assessment of what your severance entitlements are, not based on what your employer is telling you, but based on what the law actually is and the way the law actually works. The way the law actually works is that despite the fact that you're only a 9-month employee, your severance entitlements may be several months. And that doesn't just apply to you, Grace. It applies to any other short-term employee out there. Don't just assume that because you've been with the company for a short period of time, your severance entitlements are either nothing or maybe only 1 or 2 weeks. Almost always that's not the case. Excellent question, Grace. Thank you again for that. All right, next up in line, and we'll have to start wrapping up. That is, but 2 more questions to go here. Babak Ristin, if I'm pronouncing that correctly, asks on YouTube, I was hired last year right before someone went on maternity leave. I took over her role and she was on leave. As she returned this year, I was laid off soon after as part of a mass layoff. I am only offered 1 month severance, including notice period. I left my previous management job I was in for 4 years to join this new firm. Should I be entitled to more? Excellent question, Babak, and right up the alley of what we were previously discussing with Grace. Simply because you were it sounds like you're a relatively kind of short-term employee. If you only really kind of took over the role for a maternity period, you may very well be owed more than just 1 month of notice or 1 month of kind of combined notice and severance. Again, your age, position with the company are going to be relevant factors in addition to your length of employment, of course. The fact that you left your previous management job is only relevant if you were recruited away from the position. So if you left that job, but you were the one that kind of applied to this position and were interested in the position, and you were the one that reached out first, that's not going to be a relevant factor. The fact that you left that other job is a non-factor when it comes to the severance analysis. It may very well be a factor, however, if you were recruited away and enticed away from that previous employment. If you were enticed today or what's called induced, if you were encouraged to leave that previous job to join this company, and then a year later you're let go, well, that is going to be a factor, actually, that's taken into account and might actually enhance your severance entitlements. It, again, may also be important to review any contract that you signed with the company. The point here is, again, don't assume that the 1 month they've offered you is correct. Even as a short service employee, you're going to be owed more. Visit pocketemploymentlawyer.ca. Send us your contact information. Give us a call at the office. There's so many different ways to get a hold of us. There's no excuse here. Make sure you speak with one of our employment lawyers. Let's make sure that you get the proper advice that you need in the circumstances. Again, going back to the start of the stream, do not sign off on any kind of severance offer if you haven't received that advice. All right, wrapping it up very quickly. Last but not least, Barbara asks on Facebook, do employees who started working remotely during COVID have to go into the office if requested? Barbara, it really depends on the terms of your employment. There are 2 ways that terms of employment could be established. And this is what I would suggest you do. Have a look at your contract of employment. If there's anything in there that allows the employer to call you back in the office, despite the fact that you're working remotely, then your employer is allowed to do so contractually, right? They would have the right to recall you if it's in black and white in an employment agreement or in a employee handbook or whatever contractual document there may be. If that's not the case, Barbara, if there's nothing in writing, right, that speaks to what the employer can do and not do when it comes to remote work, well, then the implied or established terms of employment matter. Meaning, if your understanding when you started this job was that you would be allowed to work from home indefinitely into the future, and you accepted the job at that basis, that was the understanding at the time. Well, interestingly now, the employer can't really change its mind, right? This work from home situation has become an established term of employment, right? It's an implied term of employment, even though there's nothing in writing. This is the status quo. And you actually have a right to refuse returning back into the office if that is the status quo. So it's either an express or written contract that applies here. And so look to the contract, number one. If there's nothing in the contract about whether or not they can call you back to the office, then what are the implied terms of employment? If the implied or kind of implicit terms of employment are that you were expecting this was permanent, right? Work from home was permanent, well, then you do have the right to push back and say, no, thank you. We will leave it at that, guys. Thank you. Excellent questions today. I have to say, thank you all for tuning in. We're going to be actually doing another live stream with a colleague tomorrow at 1:30, as we do throughout the week, of course. So if you didn't get your question asked today, make sure to tune in tomorrow or next time, whenever you get a chance. We obviously do these live streams on a regular basis. Thank you all again for tuning in. I wish you the very best for the rest of the week. And until next time, so long and take care, everyone. Bye-bye.